We are live.
Good morning.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much, and good morning. Welcome to the Massachusetts Appeals Court oral argument for May 1, 2020. My name is Mary Thomas Sullivan. Today, your panel will consist of me, Justice Jeffrey Kinder, and Justice James Lemire. This is a virtual sitting located in a virtual replica of our courtroom. We find ourselves in extraordinary times, adapting to a global pandemic. We owe a very deep debt of gratitude to our clerk of the appeals court, the staff of the clerk's office, the court administrator, the judges, and the law clerks whose creative vision and seamless collaboration has made this remote sitting possible. Under normal circumstances, we would find ourselves in Worcester today, hosted by members of the Worcester Bar Association. Today is May Day, known as Law Day in the United States, and each year on that day, we travel to Worcester to share that day with the Worcester community, which is also watching this on live stream. The panel wishes to extend its thanks to Rob White, president of the Worcester Bar Association, for getting the word out and making virtual participation possible. We also wish to extend a special welcome to Worcester North High School students who were meant to be with us in person. We hope to be with you next year. Law Day was established in 1958 by President Dwight D. Eisenhower, and its purpose is to honor the rule of law. On the very first Law Day, President Eisenhower said, and I quote, "In a very real sense, the world no longer has a choice between force and law. If civilization is to survive, it must choose the rule of law." This year, the theme of Law Day was the 100th anniversary of women's suffrage. And so in one day, we are reminded of two great pillars of our democracy, the right to vote and the importance of a free and independent judiciary. Many people sacrificed over many generations to make it possible for us to sit with you today. And though today we contemplate a different future, we will weather our challenges as they did before us. And we do so in part by being here today to uphold the rule of law without interruption. We are hearing 5 cases today, and we will proceed as normal. Each advocate speaks one at a time. Each advocate will have 15 minutes. You are encouraged to get to the meat of your argument. We have read your briefs and your papers thoroughly. There is no rebuttal, and we will be taking a very brief break after the 3rd case. During that time, the live stream may go offline, and indeed the live stream may stop between cases, but we will come back on. This proceeding is live and being recorded. Anything said during the proceeding will be heard by all of those observing and become part of the record, just as in a physical courtroom. If there is a technical problem with this session, or any participant inadvertently drops out or is unable to hear, the session clerk or a justice may announce that there is a problem with the meeting, and we may instruct that the argument is being suspended momentarily. But with any luck, that won't happen, and we will proceed as normal. And we do so now by calling the first case, case number 19P1480, Commonwealth versus Holmes. Counsel, would you identify yourselves for the record?
Good morning, Your Honor. Joseph Schneiderman. I represent Craig Holmes.
You may proceed. Oh,
sorry.
Thank you, Your Honor. May it please the court, I am Joseph Schneiderman. I represent Craig Holmes. The Commonwealth's evidence was insufficient as to all three counts, individually or collectively, because the witness's perception of Mr. Holmes' ability and intent to carry out his threat of murder required unreasonable resort to speculation or conjecture, and the evidence of future interactions after the threat belies such perception. Regarding all counts, the court officers, although they did not see or hear the threat themselves personally, saw the reactions that each of the victims had and did not act affirmatively to either separate Mr. Holmes from them or otherwise take action such as to place Mr. Holmes under arrest. The Commonwealth in their brief makes a suggestion that future reactions are irrelevant. That is not what the law is. This court many years ago in Commonwealth versus Winter, which is the subject of a 16L letter I submitted earlier today, said, although apprehension is relevant to the perception of a threat, said apprehension is relevant to the perception of a threat, and it is probative. Excuse me, Your Honors, I apologize. Regarding each victim, as to Damaris Hernandez, there was no relationship between Damaris Hernandez and Mr. Holmes. Miss Hernandez is Mr. Holmes' spouse's mother, and she admitted during her direct testimony they have no relationship between her and her daughter. She does not have contact with Mr. Holmes. The remarks occurred literally and figuratively in passing. Mr. Holmes said what he said in the vestibule of the courtroom. He kept going. There was nothing there. Ms. Hernandez was also there to support young Nicholas LaCurry, who was the child at issue in the court proceedings in the probate court. There was no relationship. There was no context. There was nothing. It was the Commonwealth's burden to establish that, and they simply didn't. Moreover, there is evidence in the record that there were continued interactions, which Ms. Hernandez did not take steps to affirmatively end. Ms. Hernandez saw Mr. Holmes at the Big E, that's at page 63 of the trial transcript, and again at Bay State Medical Center, two prominent locations in public, and both of them went about their business. Ms. Hernandez was not alarmed. There was no evidence in the record of that. This case is distinguishable from past cases of this court and of the Supreme Judicial Court, such as Shawley or Milo M., where in Shawley, the defendant there had a long record of protesting at the Quincy District Court. And indeed, also in Shawley, which ties back to my point about the involvement of the court officers, one court officer in Shawley specifically left his post at a courtroom and followed Mr. Shawley as he went on his tirade at the Quincy District Court.
Mr. Schneiderman, can I interrupt for a moment?
Of course, Your Honor.
You mentioned context earlier.
Yes, Your Honor.
As I recall, your client admitted that he had a poor relationship with the LaCorys and also that he was angry after the hearing. Why doesn't that give context to our consideration of his later direct threat?
Your Honor, I have two responses. First, Mr. Holmes' rights became fixed when he moved for a required finding of not guilty at the close of the Commonwealth's case. So to the extent that there's any sort of a conflict between his testimony and between what was presented in the Commonwealth's case, he fixed his rights by moving for a required finding at the close of the Commonwealth's case. To my second response, though, is this. Mr. Holmes admitted that there was a contentious relationship, but he also denied the overt threat in his own testimony. He said to Damaris Hernandez, I don't recall the page site at this instant, but he said to Damaris Hernandez, you'll never see your children again. That issue of his own testimony would only become relevant as to whether or not the Commonwealth established a deterioration. So any issue.
But if we are viewing the evidence in the light most favorable to the prosecution, there certainly was evidence of a hostile relationship, and there was evidence of a direct threat, was there not?
There was evidence of a direct threat, Your Honor. I agree with that. I think inferring a hostile relationship as to all three witnesses is a bit of a reach. Damaris Hernandez did not testify to any sort of a relationship with Mr. Holmes. She just said at page 56 and 57 of the trial transcript, I have no relationship to my daughter. I don't see Mr. Holmes very frequently. To Your Honor's question about what else was going on, Harriet LaCourie acknowledged that there were staring and dirty looks exchanged back and forth, but Mr. Holmes, or I'm sorry, that's backwards. But staring and dirty looks do not in and of themselves connote the necessary menace. And more broadly, to Your Honor's question, I apologize for going with 3 responses when I said I had 2. The Commonwealth bears the burden of proving this specific 4th element of threatening, which is that could a reasonable person perceive the ability and intent to carry out their threat? The Commonwealth cannot resort to speculation. As I suggested in the brief, and I want to be sure the court understands this, this is an either or. Either it is insufficient as to 1, 2, or all 3. And second, the Commonwealth has to prove that the perception was reasonable. The evidence in the record in their case in chief as to the witnesses requires some jumping, and there is evidence that tilts the other way. In that context, that is not enough to satisfy the Lattimore standard, particularly under this specific element in these quantums of proof.
You know, so many of these cases involving threats deal with threats made to a third party or threats that are somewhat ambiguous. It's difficult to imagine a more direct threat than "you're all dead, I'm going to kill you." And against the backdrop of that I've mentioned regarding the hostile relationship, it seems to me that there was ample evidence. Am I missing something?
Your Honor, I agree. Let me be emphatic. I agree. "I'll kill you all" is enough to take us into the ambit of the threat statute. That I agree with. What I disagree with is the notion that the perception that Mr. Holmes had the specific ability and intent to commit murder is borne out by this record. The court officers, there was testimony in the record that the witnesses sought out the assistance of court officers. And indeed, it's a charged hearing. Certainly, Your Honor is correct that the case law has talked about this issue about whether or not a third party hears the threat or whether it's communicated. The court officers could have acted to stop Mr. Holmes, and they didn't. I think in light of that, it requires speculation to believe that the threat was genuine or that he indeed had the ability and intent to carry it out of murder. And indeed, Harriet LaCourie and Damaris Hernandez both testified. Mr. Holmes said what he said: "I'll kill you all, your children are dead." And he kept going. It's not like Shali or Milo M. In Milo M., the juvenile lurked and lingered, trying to seek out his teacher. In Shali, Mr. Shali went all over the Quincy District Court, specifically sought out the trial prosecutor. I think it still requires a resort to conjecture or speculation, and resort to conjecture or speculation does not satisfy Lattimore. More to Your Honor's question, though, about what went on. Nicholas LaCourie admitted, even though I have a contentious relationship with Mr. Holmes and I'm scared of what he could do, on cross-examination, Mr. LaCourie further acknowledged he didn't take any self-help measures, such as to arm himself. He also did not seek to arrange or to rearrange, the custody relationship between himself, Damaris Cruz, and Mr. Holmes, where Nick Jr. was in the middle of it. I think
by contrast, he did testify that he was scared as a result of the threat.
Certainly, Your Honor, that does go to this 4th element of fear. And it goes back to where I started with when I opened, which is apprehension is highly relevant. The rest of the narrative, though, belies this specific 4th element of threats, and that is the crux of it.
Mr. Snyderman, you make an issue about what the court officers didn't do. It seems as though they at least separated, so they left at different times or separated their departure. The maximum penalty for this offense is what? Do you know what it is? It's a misdemeanor, correct?
Yes, it is, Your Honor.
I'm sorry. The court officers, even though they may have arrest powers, weren't able to arrest this individual as they didn't observe the threat. It wasn't a misdemeanor that occurred in their presence.
I see Your Honor's point, which was not a misdemeanor that occurred in its presence. I'm actually very glad Your Honor asked me about this issue involving the court officers, because yes, there is the issue about the court officers not necessarily being able to arrest Mr. Holmes for threats itself, but the court officers could have arrested him for something else, perhaps disorderly conduct, perhaps disrupting a court proceeding, or indeed perhaps for simple assault. I appreciate Your Honor's point that the penalty for threats is a misdemeanor and the officers would need to be percipient. But given that Mr. LaCorey's reaction was to grab a court officer in his own testimony, the court officers could have interceded and done more, and they didn't. And because the court officers could have interceded and done more, it requires speculation to reach that issue. I appreciate Your Honor's point, though, that this is the maximum penalty for threats, if memory serves, is 6 months in the House of Correction. But the court officers still could have taken additional action to separate them. I think I've covered just about everything. Unless Your Honors have further questions, I ask for a reversal, whether it's on 1, 2, or 3 of these complaints. And I thank you kindly for your time.
Thank you. I have no further questions.
No further.
Thank you very much.
Thank you, Your Honors.
You may proceed.
Thank you. May it please the court. Travis Lynch. Oh, we don't have a clock.
We
It's
do.
there.
We do.
Oh, okay. I can't see it. Anyway, Travis Lynch, Assistant District Attorney on behalf of the Commonwealth. The defendant.
Attorney Lynch, if you want to take a second to put it in participant view, you'll be able to see the clock.
Okay. I see.
If you want to take a second to do that, that's
I have it now. Thank you.
okay.
I apologize. The evidence here was plainly sufficient under the Lattimore standard to support the convictions. I think cases such as Maiden and Shawley make clear that the court context of the defendant's threats here indicate that it's reasonable to take the defendant's death threats as a threat under the circumstances. And in Commonwealth, also in Maiden, I would point out the court stated in Maiden there's no need for the defendant's threats to cause actual fear or apprehension in the victim. It's an objective standard, whether it would be objectively reasonable to take it as a threat under the circumstances. So besides which, the defendant, or all 3 of the targets, said that they felt threatened, or so Mr. LaCorey stated that he felt threatened. Harriet LaCorey stated that she felt scared, and Damaris Hernandez felt that she felt kind of in shock. All of which was justified and completely reasonable in face of the defendant's death threats. And unless, so.
I have a question for you, Mr. Lynch. In your brief, you seem to suggest that the evidence of the post-incident conduct was not relevant. Are you suggesting by that argument that that evidence should not even have been admitted?
I don't believe there were objections generally to the evidence that was admitted. So I'm not saying that it shouldn't have come in. Perhaps it would have been better to say it doesn't undermine the sufficiency of the evidence, of the Commonwealth's evidence. That might be a better way to put it.
So I take it then you agree that there are circumstances in which post-incident conduct could be relevant.
Right, but I would suggest that here, where a lot of that post-incident conduct occurred months after the threat. I mean, I think you're looking at whether it's reasonable at the time the defendant makes the threat to take it as a threat, not months later.
Correct, but if, for example, they had chosen to go out to lunch together after the hearing, that clearly would be relevant evidence to what was perceived at the time, correct?
I mean, it could be, but I wouldn't say that it fatally undermines the sufficiency of the Commonwealth's proof. That's what I would say.
I have nothing.
Thank you. Oh, sorry.
All right. If you're done,
I'm content to rest on my brief unless there's any
All right.
further questions.
And I have no further questions either. Thank you, counsel.
Thank you.
Thank you, counsel.